On the news at 10, we're staying in Abuja, where, as it stands, the ruling All Progressives Congress can now conduct its planned national convention come 26th March. And this happened on the day a high court in the Federal Capital Territory vacated an order stopping the national convention of the party billed for March 26. And while delivering judgment on the matter, Justice Bello Okawo argued that a political party cannot be sued by its member. The judge relied on the recent Supreme Court judgment, that of Aguma versus APC, to conclude his ruling. The ruling followed the twists in the leadership of the ruling party as it plans for the convention. Recently, there were tussles over the leadership of the party when Governor Sani Bello of Niger State took over as the acting national chairman of the APC in the absence of the caretaker extraordinary convention planning committee of the party, Governor Mai Malabuni of Yobe State. But that has now been settled, as Governor Buni said all actions taken by his Niger State counterpart remained valid. He reiterated that he duly transmitted power to Governor Bello, who acted on his authority while he was away. Meanwhile, the Attorney General of the Federation, Abubakar Malami, has been ordered by the Federal High Court sitting in Umuahia, Abia State, to immediately delete Section 84, subsection 12 of the amended Electoral Act. Justice Evelyn Ayadike earlier today held that the section was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever, and therefore cannot stand because it's in violation of the clear provisions of the Constitution. The section says no political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. TVC's Prince Uba has details.
Last month, President Muhammadu Buhari signed into law the long-awaited amended Electoral Act. The president raised serious concern on Section 84, subsection 12, which he said is in variance with some of the provisions in the 1999 Constitution as amended. President Buhari went ahead to write both chambers of the National Assembly seeking amendment of the section, but the Senate rejected the president's requests. Worried by this development, a legal practitioner, Nduke Dede, headed to court for nullification of that section, which the court agreed with him. Reacting to the judgment, counsel to the plaintiff, Emeka Ozan, stated that the National Assembly is not required to further make any amendments to the section.
It's inconsistent with the rights of Nigerian citizens when read with Section 66 of the Constitution, 107, 137, 182, and now nullified Section 84, subsection 12 of the Electoral Act. And as equally has ordered the Attorney General of the Federation to delete Section 84, subsection 12 of the Electoral Act forthwith. Now, the implication of this is that it has provided a congenial atmosphere for politicking and political space for 2023.
Counsel to the Attorney General of the Federation, Chris Level, also agreed with the judgment.
Originally, we honestly believed that it was inadvertence on the part of the National Assembly. It was a big error. And being gentlemen and distinguished senators and the members of the House, I think they will now go back and do the right thing, since the court has made pronouncement on it, and that put to rest every other issue regards to that, so that we can move on with the national issues that are besieging us as a country and as a nation.
The presiding judge, Evelyn Anyadike, holds that the Constitution has already stipulated that appointees of government seeking to contest elections were only to resign at least 30 days to the date of the election, and that any other law that mandated such appointees to resign or leave office at any time before that is unconstitutional, invalid, illegal, null and void. Prince Oba, TVC News, Umuahia.
Let's now talk to spokesman of the House of Representatives, Benjamin Kalu, who joins us live from Abuja. Honorable Kalu, we're told that the import of this judgment is such that Section 82, or rather 84, subsection 12 of the Electoral Act is now no longer existing, and that the National Assembly is no longer required to make any further amendments to this portion of the law. How are lawmakers and indeed the House of Reps responding to this?
Yeah, thank you very much. First of all, let me mention that it is unprofessional for the spokesperson of either the Senate or the House of Representatives to react to what we consider a social media report on a judgment or traditional media reports on a court judgment. The reason being that we are in the age of misinformation, fake news, and all the rest of them. The National Assembly is yet to be served with the judgment that is being referred to. We are not aware of this particular proceeding. We are not even sure if we are necessary parties to this particular court proceeding. And I think it's only fair for us to wait and be served with the judgment so that we ask relevant questions as to why we were not properly served if we are parties to this particular judgment, this particular court proceeding. And if not, we will now know what to discuss with regards to the content, the substance of the matter, or the technicalities around it. Because looking at section 66(1), section 107, 137, 181, that this was relied on, that is in conflict with what 8412 says. Speaking to that will be a misnomer. We have to wait until we get a copy of the judgment and see if we are necessary parties, what options are open to us. But the National Assembly is actually also feeling that, granted, that this emanated from right proceeding without technical error, the speed of implementation as alleged by a press release that is circulating coming from the Attorney General, is what we are looking at as lawyers. And we're saying whether the decision that took place in Umuahia today, the enrolled order of the Federal High Court in Umuahia has been served on the Attorney General to enable him go into implementation immediately, or whether the office is relying on this social media report. So we are saying it is important for us to wait and see how all this plays out, because we know that as a court of first instance, there are rooms for any interested party to go exercise his right of appeal. And unless we are saying that this decision forecloses the right of appeal of the parties, if we are parties, because we're not seeing the processes.
I get your point, Honorable Kalu, and your position on waiting to be served. However, there are a few more things that we know. The Attorney General of the Federation has reacted, saying that the federal government will gazette the Electoral Act and indeed remove this contentious section as ordered by the court. What I'd like to ask you, however, is whether or not the provision of the Constitution in this regard is also under the purview of the ongoing constitutional review. And is that an area that lawmakers are going to be looking to going forward?
No, before even going to that, the question we should ask is whether the principles of separation of power is being upheld with such decision, which define the parameters of operation of the arms of government. Is it allowed for the court under any guise to take the responsibility of lawmaking to the executive instead of the legislature? The consequential order should have been to compel the National Assembly to amend or delete before pushing it into to print, but to have a consequential order that removes the job of lawmaking from the National Assembly and place it in the hands of the executive is something that calls for a review, because you cannot even add a punctuation to any act of parliament, any piece of legislation made by the parliament, without the input of the National Assembly. So in this case, you are saying delete a particular section. Executive should delete a particular section, which means it's an act of making the law that you are taking to the executive arm of government. So it's one of the things we will look at the time we get the true picture of this whole scenario. But
Honorable,
now, we will wait until we have a hard copy.
Let me just drop this.
Certified true copy.
The AGM
judgment.
The office of the AGM seemed to, be replying to your point by making reference back to the Constitution, Section 287 to be precise, that makes it a point of duty to oblige, or rather obey, every of such order coming from a federal high court and every of such courts. And it's why I called your attention to the Constitution. In this regard, they say it's the go-to for whether you are a lawmaker or a member of the executive.
No, there is no, it increases or activates the right of appeal by any interested party that is out to protect the supremacy of the Constitution that has empowered the arms of government to operate within their defined parameters. The act of lawmaking belongs to the parliament. If you are deleting, if you are editing, if you are rewriting, the consequential order should refer it to the National Assembly. They will carry out that particular amendment or rewriting and then push it out for printing. But it would be a very dangerous precedent if an incursion into the powers and responsibility of a National Assembly is encouraged by the courts in a constitutional democracy. But like I said, we cannot really comment on this until we see the true court judgment, the hard copy of the court judgment, review it and then know a position. But to foreclose appeal from interested party with the speed of implementation might be something that might cause wastage to government. For example, if somebody goes to appeal after you have printed, what happens to that? Let us wait until we see the judgment, then we'll take a position on that.
Well, we'll wait to hear the official position of the National Assembly in this regard. Spokesman, House of Representatives, Honorable Benjamin Kalu, thank you for talking to us tonight.
Thank you very much.